We often picture legal battles with, those charismatic lawyers arguing court. But think about this for a second. Back in 2017, a really huge amount, $429 billion, was spent on litigation just in the U.S.
Wow, that's enormous.
It is. And what's really surprising is that less than 60% of that actually ended up with the plaintiffs.
So where did the rest go?
Well, a big chunk is fees, obviously. And get this, the U.S. has the most expensive tort system in the world. We're talking over $3,300 per household.
Per household? That's quite a burden.
Exactly. Now, behind all these big numbers, there is a key player who often works behind the scenes. The accountant.
Right. Not the first person you think of in a courtroom drama.
Definitely not. So today we're doing a deep dive into the really fascinating kind of hidden role these financial experts play in our legal system.
Yeah, we've looked at some great material on this, and it's way more than just, crunching numbers. Accountants in litigation can actually wear several different hats. Well, they might be a consultant, advising the lawyers privately, or maybe a summary witness, making complex data easy to grasp. Or, the big one, an expert witness giving specialized opinions. Sometimes they're even appointed by the court as a master.
Okay, quite a range.
Definitely. So our plan today is really to explore these different jobs, what they involve, and the actual impact accountants have on how legal cases turn out.
Okay, let's get into it then. So an accountant steps into this legal world. Are they just using their standard accounting playbook, or are there extra rules they have to follow?
That's a great question. And the answer is, well, both. They absolutely bring their core professional skills, sometimes called SKEET, skills, knowledge, experience, education, training.
SKEET, okay.
But then they also have to follow the specific rules set by the court or whatever dispute process they're in. So it's their usual expertise plus the rules of the legal game, basically.
Gotcha. So it's not like they can just wing it. There are definite boundaries.
Precisely, yeah. And for CPAs, especially those in the AICPA, certain ethical principles are super important here. Professional competence. For one, they can't just take any case. They need the right expertise.
Makes sense.
And then objectivity and integrity. This is huge. They have to avoid any hint of bias. Their opinions can't just be what the client wants to hear. Even the appearance of taking sides can really hurt their credibility.
Interesting. So it's not just being neutral. They have to look neutral, too.
Exactly. Now, the really strict independence rules you see in financial audits, those attestation engagements, they don't always apply exactly the same way in litigation consulting. But for an expert witness, the appearance of independence is absolutely critical. Judges, juries, they need to believe the expert is unbiased.
Right. Credibility is everything there.
And of course, confidentiality. That's always key. They can't be blabbing sensitive client info.
Yeah, you wouldn't want your financial dirty laundry aired accidentally.
Yeah.
What about potential conflicts of interest? That sounds tricky.
Oh, it really is. Accountants have to be incredibly careful. They need to spot any conflicts, actual or apparent. And that's not just with the people in the lawsuit, but their lawyers, too.
So, if they worked with the opposing lawyer years ago?
Potentially, yeah. Or had a big business deal with someone on the other side.
Yeah.
Even if it doesn't actually make them biased, if it looks like it could, that needs to be on the table disclosed. It's about any incompatible interests, real or just perceived.
Okay, so they navigate these ethical rules. How do they actually set up the job with the lawyer? Is it just a handshake?
Oh, definitely not. You need a formal written agreement, always, between the accountant and the attorney.
What does that cover?
Pretty much everything important.
Yeah.
The scope of work, like exactly what the accountant is supposed to do. Crucially, will they need to testify as an expert, or are they just consulting behind the scenes? It covers confidentiality, lays out any potential conflicts, how the job can be ended, and naturally the fees.
Right, the money part.
Yeah, just make sure everyone's on the same page and protects everybody involved.
Okay, that seems essential. Now, you hear legal phrases thrown around, like attorney-client privilege and work product privilege. How do those affect what the accountant does?
Yeah, that's a really important distinction. Attorney-client privilege, that usually protects the direct, confidential chats between a client and their lawyer. Think of it like your private conversation with your lawyer. Nobody else gets to hear it.
Okay.
Now, if a forensic accountant is hired specifically to be an expert witness, their work generally isn't shielded by that privilege. The other side can usually see it.
Right.
But if they're hired as a non-testifying consultant, their work often falls under what's called the attorney work product privilege. That's more like the lawyer's own notes and strategy stuff for the case.
Oh, okay.
So that work product stuff is generally protected from discovery by the other side. This means if a lawyer wants to keep an accountant's initial findings quiet, they'll probably hire them as a consultant first.
Huh. That's a fascinating tactical point. So the role they play dictates how much the other side gets to see. I mean, let's switch gears a bit. Becoming an expert witness, that sounds pretty official. What does that actually mean?
It is, yeah, it's quite formal. First thing is understanding the difference between a fact witness and an expert witness.
So,
A fact witness or lay witness just testifies about what they personally saw or know. Like, I saw the car run the red light. An expert witness, though, uses their special knowledge training experience to help the judge or jury understand something complex, something technical.
so not needed for simple stuff.
Exactly. You don't need an expert to explain that, someone didn't pay a bill. But if you're talking complex financial fraud.
And you need the expert.
Right.
And it's really crucial to remember, experts testify about facts within our expertise, not the law itself. The only real exception is maybe explaining foreign law.
So an accountant explains the complex financial stuff, but they don't say, yes, this was legally fraud. Precisely. They explain the numbers, the accounting principles, maybe how something deviated from standards, but judging whether it meets the legal definition of fraud, that's the judge's job.
Got it. So a lawyer decides they need an expert. What are they looking for? It can't just be having a CPA license, right?
Oh, absolutely not. Lawyers have a pretty detailed checklist. They want someone with deep, relevant experience in the specific issue of the case. Maturity helps. A solid professional track record.
Experience counts.
Big time.
Yeah.
They need someone current in their field, respected by peers. And focused expertise is key. Knowing a lot about one specific area is better than knowing a little about everything.
Makes sense.
They also tend to shy away from people who look like professional witnesses. Folks who seem to just testify for a living.
Ah, the hired gun perception.
Right. They want consistency, too. Someone whose previous testimony doesn't contradict what they'd say now. And then there's the human side. They need to be credible, relatable to a jury, flexible, a really good communicator, almost like a good teacher, able to break down context stuff simply.
Sounds like a unicorn they're looking for. Is there any way for lawyers to check someone's track record?
Actually, yes. There's a resource called Dobert Tracker. It's a database. It requires a subscription, but it lets lawyers search reported court cases.
To see what?
To see if an expert's testimony has been challenged before, maybe even thrown out by a judge. It's a way to check for, skeletons in the closet.
Wow, that's serious due diligence. Okay. Lawyer finds the perfect expert. How do they get the court to officially accept them? I've heard terms like Dobert standard and Fry standard. What are they?
Right. Those are the two main gatekeepers, basically. The legal standards courts use to decide if expert testimony is even admissible if it can be presented at trial.
Okay.
The older one is the Fry standard. It's still used in a few states. California, Illinois, New York are examples. Under Fry, the big question is, are the experts' methods or principles generally accepted in their field?
So do other experts agree with how they did it?
Pretty much.
Yeah.
The judge kind of defers to the expert community.
In Dobert. That sounds more common now.
It is. Daubert came from the Supreme Court, and it's the standard in federal courts and most states now. It puts more responsibility on the judge. The judge acts as a gatekeeper.
Gatekeeper.
Yeah, they have to assess not just if the testimony is relevant, but also if it's reliable. Daubert laid out factors judges should look at. Has the theory been tested? Peer-reviewed? What's the error rate? Is it generally accepted? Are there standards controlling its use?
So a much deeper dive by the judge, not just, is it generally accepted?
Exactly. It's a more rigorous evaluation. And that leads to what you mentioned, Daubert challenges.
Right. What are those?
That's basically when one side tries to get the other side's expert witness disqualified. They file a motion saying, hey, judge, this person shouldn't be allowed to testify.
On what grounds?
Usually they argue the expert isn't actually qualified on the specific topic, or, more often, that the methodology they used isn't reliable or doesn't really fit the facts of the case. These challenges can be simple motions or turn into mini trials themselves, with hearings and testimony.
So, for you listening, this Daubert thing isn't just legal process. It shows how vital it is for experts to use solid, verifiable methods. A shaky foundation can sink the whole testimony.
Absolutely.
So what specifically makes a judge say, nope, this expert can't testify? Is it just not having enough degrees?
Not really. Credentials matter, sure, but just being a CPA isn't automatically enough. The judge needs convincing that the person has the right knowledge, skill, experience, training, and education for the specific issues in this case.
Specificity is key.
And crucially, their testimony has to be based on enough facts or data, use reliable methods, and apply those methods properly to the case facts. Courts really clamp down on speculation, opinions based on flawed science, or experts trying to tell the judge what the law is. That's a definite no-no.
Right, stick to your expertise. So any advice for experts to avoid getting tripped up by Dober?
Yeah, some common advice is to state opinions are offered to a reasonable degree of professional certainty. Clearly lay out the research they relied on, mention if it was peer-reviewed, cite objective sources. It's all about showing a solid, transparent basis for their judgment.
Transparency, clear link to established knowledge. Got it. What if an accountant does get disqualified? Is it just, okay, you don't get to talk, or is it worse?
Oh, it can be much worse. For the client who hired them, it could cripple their case, maybe even cause them to lose if that testimony was essential.
Ouch.
And for the accountant, it's a serious blow to their professional reputation. Makes it way harder to get hired as an expert again. It could even lead to a malpractice lawsuit from the unhappy client.
Wow.
Yeah, there have been cases where judges have made really harsh comments in court about disqualified experts. That stuff sticks. The stakes are definitely high.
Definitely sounds like it. Okay, so let's say the expert clears the Dabert hurdle. They're approved. What's next? How do they actually prepare the testimony itself?
Well, a huge part of that is the expert report. This is a really detailed written document.
What goes in it?
Typically, all the opinions the expert plans to give, the data they looked at to form those opinions, any charts or graphs they'll use, their qualifications, how much they're being paid for the case, and, importantly, a list of other cases they've testified in before.
Seems comprehensive.
It is, and it's a vital tool. The expert can actually refer back to their report while they're testifying in court. It's like their roadmap.
Okay, the blueprint for their testimony. You mentioned reasonable degree of professional certainty again. How certain do they actually need to sound?
That's a great point, because that phrase, reasonable degree of professional certainty, it sounds definitive, but it doesn't actually have one clear definition across law or accounting.
Really?
Yeah. Some say it means basically more likely than not, like over 50% probability. So to be safe, especially with damages, experts often phrase things carefully. They'll say their testimony is reliable, relevant, meets the accepted standards of certainty within their field.
So it's nuanced.
Very. And lawyers know this. You can bet that cross-examination will poke at how confident the expert really is, what they mean by reasonable certainty.
Okay, so it's about well-supported judgment, not absolute proof. What about writing the report? Can the lawyer just write it and have the expert sign it? Like ghostwriting?
Oh, absolutely not. That's a huge red flag. The report must be the expert's own work. Their analysis, their findings, their opinions.
But the lawyer can help, right?
Sure, lawyers can guide on format, make sure it follows court rules, things like that. But the actual substance has to come from the expert. There are cases where reports got thrown out because they look like the lawyer wrote them. The courts are really clear. Drafting the opinion from scratch and just having the expert sign off, not okay. The expert needs to be deeply involved in the analysis and the writing.
Right, you want the expert's brain, not the lawyer's spin on it. What other big mistakes should experts avoid when prepping reports and getting ready?
A major one is side-taking or doing result-oriented work. They have to stay objective and independent. If it looks like they're just cheerleading for their client, their credibility plummets.
Like that valuation expert example you mentioned.
Exactly. Courts hate that. Other key things. Talk thoroughly with the lawyer to really grasp the issues. Focus on hard data, not just gut feelings. Ground opinions in solid sources and standards. Clearly link theories to the case facts. Use clear, objective language. Never give legal opinions. Stay in your lane, expertise-wise. And be meticulous. Even small mistakes in the report can be blown up by the other side. Oh, and write in the first-person active voice. Define your terms.
Seems like a lot to juggle.
It is. And another really critical point. The expert's notes, their calculations, drafts, spreadsheets, basically all their working papers, are usually discoverable by the other side.
Everything.
Pretty much, especially if they're testifying and relied on that stuff. Unlike the lawyer's work product, there's generally no privilege protecting the testifying expert's background materials. So keeping incredibly organized, complete records of everything they did is absolutely essential. Every calculation could end up under a microscope.
That sounds incredibly stressful. Do experts do other things besides write reports and prepare to testify? How else do they help the legal team?
Oh, yeah. They play a big role behind the scenes, too. A really important job is reviewing the other side's expert reports.
Picking them apart.
Essentially, yes.
They
They
get-
analyze the opposing expert's methods, look for weaknesses, flaws in the logic, questionable assumptions. Then they help their own lawyer develop sharp, effective cross-examination questions to expose those weaknesses in court.
Ah, so they help prep for the courtroom battle.
Exactly. And they also help the lawyers just understand the complex technical stuff, recommend research, act as a translator, and a strategic advisor on the financial or technical aspects.
So they're really integrated into the team's strategy. Okay, fast forward to the courtroom. I've seen trials with all kinds of charts and graphs, even animations sometimes. Does the expert get involved with those?
Definitely. Those are called demonstrative evidence. Charts, graphs, timelines, animations. They can be super powerful for making complicated stuff clear and persuasive to a jury.
Are they considered actual evidence?
That's a key distinction. There's evidence that gets formally admitted and goes back with the jury. Then there's demonstrative evidence, which is more like a visual aid used during testimony to illustrate a point. It doesn't usually go back with the jury. Experts often work with lawyers to create these visuals.
Do they have to be careful with them?
Yes, they need to check with the lawyer to make sure they're admissible and will actually help, not confuse. But research shows people remember things much better when they see them visually, so good demonstratives can really boost an expert's impact.
Okay, visuals matter. Now, before the trial itself, there's often this thing called a deposition. What's that about for the expert?
All right, a deposition is basically sworn testimony given outside the courtroom. The expert, the deponent, sits down and answers questions from the opposing lawyer under oath.
What's the point?
A big goal is to lock in the expert's testimony before trial. If they change their story later in court, the lawyer can pull out the deposition transcript and say, "But back then, you said this." It undermines their credibility.
So it pins them down.
Exactly. And experts can be legally forced to show up via a subpoena. The whole thing is recorded, written transcript, maybe audio, sometimes even video.
Sounds intense. Any key advice for an expert giving a deposition?
Rule 1, tell the truth, always. But also, just answer the question asked. Don't volunteer extra information. Pause, think before answering. Never answer a question you don't understand. Ask for clarification.
No guessing.
Absolutely no guessing or speculating. Be careful with words like always or never. If your lawyer objects to a question, stop talking immediately and wait for guidance. You can ask for breaks. And always review the transcript carefully for errors before you sign it.
Can they look at their report during the deposition?
Yes, generally they can refer to their expert report to make sure their answers are accurate. Some lawyers even advise keeping answers super short. Yes, no, I don't recall, when possible.
Short and sweet. Okay, so they survive the deposition. Finally, it's trial time. They're on the witness stand. Any tips for that? It seems like the ultimate pressure cooker.
It definitely can be. First basics. Be on time. Dress professionally but conservatively. Only bring materials your lawyer approved. Body language matters. Try to seem open. Keep hands visible. When taking the oath, say, "I do," clearly.
Okay, presence matters.
Absolutely. Listen to the entire question before answering. Pause for a second after the question gives you time to think, and let your lawyer object if needed.
Good tip.
Use plain language. Avoid jargon if you can.
Mhm.
Explain why you reached your conclusions. Stick to the facts and your expertise. No legal opinions. Stay calm, even if the cross-examination gets aggressive. Be respectful to the judge. Try to connect with the jury. Make eye contact. Project confidence, but not arrogance.
It's a balancing act.
Totally. Be ready for attacks on your credibility, maybe indirect ones. Remember, you're there to educate, not just advocate for one side. Be sincere. If you don't remember a specific detail, it's okay to say you need to check your notes. If you made a mistake or changed your mind on something, own up to it honestly. Pay attention. If they quote your past statements, make sure it's in context. Don't be afraid to ask for a question to be repeated or clarified. Use gestures naturally, maybe use visual aids effectively if you have them, and yeah, be prepared for challenges. Opposing counsel might question your preparation, your bias, look for technical errors, even question your truthfulness, like in that WorldCom example. Don't let ego get in the way. Jurors are influenced by experts, often just by the title, and visuals help a lot. Some experts try to be bulletproof on cross-examination, giving very little away, and be aware of the tech in the courtroom, screens, projectors, etc.
Wow, it's a real performance in a way, combining substance and delivery. Now, given how important their testimony can be, can experts actually be sued if they mess up?
That's an interesting area, and it's shifted a bit. Historically, witnesses, including experts, had quite broad absolute immunity protection from being sued over their testimony to encourage people to speak freely.
But that's changed.
Somewhat, yeah. Courts in some places have narrowed that immunity for experts. They can potentially be sued for negligence in how they prepared their opinion, like if they made a major math error. But often, they're still protected from suits based purely on the opinion itself, in many places.
So, liable for sloppy work, maybe, but not just for having an unpopular opinion.
Kind of, yeah. And even court-appointed experts might not be totally immune from negligence claims anymore.
Who usually sues them if it happens?
Most often, it's their own client, the side that hired them. The lawsuit might claim breach of contract, you didn't do what we paid you for. Or professional negligence, you didn't meet the standard of care and it hurt our case.
Can the other side sue them?
Generally, courts are pretty reluctant to allow that. They worry it would just lead to endless cycles of experts suing each other back and forth. Discourages that.
Okay, that makes sense. We've mostly talked civil cases. Does the expert's role change much in criminal law?
The core idea, providing specialized knowledge, is the same, but the context is different. In criminal cases, it's the government prosecuting someone. The burden of proof is much higher, beyond a reasonable doubt. You also have grand juries involved, issuing indictments.
And the stakes seem higher.
Definitely. Our sources mention some horror stories about forensic witnesses in criminal trials. Lying about credentials really highlights the need for absolute integrity. And yeah, sentences for things like white-collar crime has gotten tougher. Fraud, mail fraud, wire fraud, proving that fraudulent intent is key, and experts can be central to that.
Seems like an even more intense environment.
It can be. One source had a great quote. A lawsuit is like a parachute jump. You have to get it right the first time. It's tough terrain for experts.
Yeah.
Staying neutral, communicating complex stuff simply, maybe using analogies people can relate to, like comparing something complex to buying lumber, as one expert did. It's all crucial.
So wrapping up this deep dive then, we've seen accountants in the legal world have to meet really high standards, both professionally and ethically. Qualifying as an expert is tough. Giving testimony effectively is a real art, blending deep knowledge with communication skills and courtroom savvy.
Right, and the whole issue of liability shows there's a real responsibility tied to their work. It's not just theory.
They clearly bring a lot of value untangling complex financial webs for the courts.
Absolutely. They bridge that gap between complex data and what judges and juries need to understand to make informed decisions.
So a final thought for you, the listener. Think about that responsibility. Experts need to be incredibly knowledgeable, yes, but also totally credible. They translate complex facts that can genuinely change legal outcomes, impacting people's lives and the course of justice. It's a really vital, fascinating place where finance and law meet, and definitely worth thinking more about its impact. If you have more questions on this, we'd love to hear them.